mode. Hello and welcome to the Power Tools for Coalition webinar series. I'm Kinkini Banerjee and I'm the Senior Coalitions Relations Manager at USBC, and I'm so glad to have you join us for this session. The Power Tools series is organized as part of USBC's training, technical assistance, and capacity building support for our network of coalitions across the US. As you know, access is free and open to all interested coalition leaders, members, breastfeeding advocates, and to anyone involved in forming or leading nonprofit organizations in the breastfeeding field. The announcement emails are sent through the USBC's coalition announcement list, and if you're not on it, please be sure to join it. We'll send you the link for it in the chat box. As you know, USBC hosts 4 different webinar series. This series, the Power Tools ones, occurs on the 3rd Wednesdays of odd-numbered months from 2 to 3:30 p.m. Eastern. And the webinar details, registration, slides, and handouts are on our website at www.usbreastfeeding.org/power-tools. And all our session details are also sent out in the Coalition's Learning Connection, so which just takes 30. If you don't have a user account, it's just 30 seconds to get user account, and you get a lot of great resources about trainings and other resources happenings in the breastfeeding field. And as you know, that we've streamlined our access so you don't have to sign up for register for each of the webinars. You now are signed up as a series, and so once you're registered, you will automatically be getting information about the sessions, follow-up, as well as reminders about the calendar time. So all our archives, we record each of the sessions, so you can, if you're not, we understand that this is middle of the day and many of you are registered but may not be able to attend live, so you can again go to the web page and you can find archives of past sessions. So here's where you are. If you go to our website and look at across the tabs, the last one is Coalitions. Click on that and it'll show you all the different webinar series we have. Click on the Power Tools webinar and you'll find handouts for this session as well as for our past sessions. Because we have a large number of attendees today, all are in listen-only mode. However, we encourage you to submit your questions at any time during the webinar. So type them in the question box on the webinar panel. We keep about, we'll do a short Q&A session in the middle of our presentation today, and then we'll have some at the end of our presentation session as well. So please keep your questions coming. And here's how you do it. On the right side of your screen, you should see a control panel. If you don't see it, it might be minimized, so just click on that orange tab and it'll pop back out. So scroll down and you'll see just under the audio section is a blue tab which says questions. Click on it and it'll open up a text box for you to type in. And if you have any audio or other tech problems during this session, please email coalitions@usbreastfeeding.org and one of our staff members will be sure to help you. And that brings me to today's topic, nonprofit organizations practice, the top 10 list. We know how mission-driven you are in the work you do every day, and legal expertise is a key component to helping your organization succeed and get to the next level. Too often, the pressing demands of running our programs and our coalition can leave a lot of the important, vital details unaddressed. So how do we go about it? So we can think about what we have as a coalition, as a nonprofit, and what do we need to get done as an organization. So in today's session, you'll hear about the core components of using legal counsel to protect and grow your assets, how you can deliver on your mission, partner with new leadership on new ventures, and this checklist will also help you take an inventory of your organization's immediate and long-term legal needs, identify some hotspots, and understand how getting your house in order order, legal house in order, can strengthen your ability and really help you advance your mission and seize the next big opportunity. And the best thing about some of the things you'll hear today is how legal counsel, timely legal counsel, can actually solve some of your problems by preempting them and preventing them and build the right context for your strategic planning as well. So I am delighted to introduce today's presenter, Lisa Hicks. Lisa is a partner at Venable, a legal firm with expertise in all areas of corporate and business law, complex litigation, intellectual property, and regulatory and government affairs. One of her specialty among many expertises that Lisa Hicks has is nonprofit organizations practice. She concentrates her practice on counseling charities, trade and professional associations, and other nonprofits on a wide range of legal topics, including tax exemption, intellectual property, corporate governance, and antitrust, among others. And Lisa brings just a great depth and breadth of experience in the nonprofit sector, having served in various capacities at nonprofit organizations, including being the founding ED of the Memorial Institute for the Prevention of Terrorism and Development Director of the East Harlem Block Schools. This experience has included representation before members of Congress and federal agencies, and Ms. Hicks is the former chair of the American Society of Association Executives in the Washington, D.C. Legal Symposium, and a former member of ASAE's Legal Section Council, and now she's currently a member of the Finance and Business Operations Committee of ASAE. So it's a real treat for us to have Lisa with us today, and we are so glad to have you present. So I am now going to turn it over to Lisa.
Thank you so much for that kind introduction. All right, Kinky, I think we should be all set. I want to also minimize this, though, however, so that people aren't having to see this.
Yeah, we don't see your control panel, so we're set.
Okay. Perfect, perfect. All right, well, good afternoon, everybody. Thank you for making the time to be on this webinar. As Kinky mentioned earlier, I like questions to come in as they occur to you. We can stop in the middle to ask some of those questions, but we are going to be covering a large number of topics today. So if something comes up, feel free to send your question in. It won't throw me off at all to be able to answer it. In fact, one of the things that I like is audience interaction, so don't be shy. And as always, there are no dumb questions. If you're wondering it, somebody else is wondering it too. By way of introduction, again, my name is Lisa Hicks. I'm a partner in the nonprofit organizations practice. I'm going to give you a summary of 10 issues. Some of these issues I go into in greater depth, so there will actually only be about 7 issues, some of them with greater depth, that are some of the very highest topics in tax-exempt organizations. My understanding is that the people I'm speaking to have various roles within state coalitions, and that some of your coalitions are at different places in your life, i.e. you may be separately incorporated, you might have C3 status, you might have a fiscal sponsorship, and so I'll try to make make my examples as applicable to all of you as possible. But if you're wondering how this particular guidance applies to you, again, just ask. All right, issue number 1, governance. I'm actually going to talk about a few things in governance, but one of the things that I always like to start with, I do a lot of public teaching to people who are in similar positions as you, a lot of public teaching to board of directors. And one of the first questions I always get is, what is a nonprofit? How is it different than a tax exempt? And how does that uniquely impact my legal duties, my legal concerns, etc.? So at a high level, again, what governs a nonprofit entity? There are really 2 pillars that govern a nonprofit entity. The second pillar I'll be talking about more later on in the slides, although it's not the primary focus of today. The first pillar really is that most of your organizations, if not all of your organizations, are incorporated at a state level. And that because of that, you have certain requirements related to board, to voting, et cetera, that end up impacting your, not only your legal compliance, but the prospective liabilities of those associated with the organization. The second pillar, and I'll talk about more about it later, is that in addition to being incorporated at a state level, your organizations are also tax exempt. My understanding is that the vast majority of you are C3 charitable and educational organizations. Some of you may be C6 trade and professional societies. I'm going to focus more on C3s, but I represent both and can answer questions about both. So let's talk first about the first pillar. Your organizations are incorporated, again, at a state level. That state, I get this question a lot, does not have to be the same state that you are located in. In fact, this is the reason that most organizations are incorporated in Delaware. It can really be any state. Incorporating means a couple of things. One is that it makes your organization subject to state corporate laws. And that will define the requirements around director voting, annual filings, decision-making, et cetera. One of the best pieces of advice I can give you is maintain your state corporate filings. And if you aren't sure right now where you're incorporated or if those state corporate filings have been maintained, go to, first of all, ask for a copy of your Articles of Incorporation, but also go to your local state corporation commission. Let's say you're in DC and your articles indicate that you're registered in DC. What you would do is go to the DC State Corporation Commission, type in, do a corporation search, type in your name, and see if you are still in good standing. If you aren't, often that can be addressed pretty easily by taking care of some back reports. But the reason that's so critical is this. Incorporation and maintaining good standing at the state level is what gives, this word I have highlighted here, a corporate shield to the organization. The corporate shield means that, kind of to contrast it from a partnership or from other forms, means that the individuals who sit on the board, the individuals who are the volunteers, the individuals who, if you have staff or on staff, are not individually responsible or liable for the liabilities that may accrue to the organization, outside of individual negligence and some things that are deeper than what we can talk about today. But that corporate shield really only exists so long as you're a valid corporate entity. If you haven't incorporated yet, don't panic. There are in many states what's called unincorporated association statutes. Most likely there is a fix for this, but one of the best things that you can do to understand where your organization is right now is to go and to make sure that you are incorporated, that again you are in good standing, and so that you know that you have that corporate shield in place. Related to the corporate shield, state corporation requirements. So we talked about what happens if you incorporate in a particular state. That means I'm originally from Oklahoma. Let's use the example of Oklahoma. I incorporate in Oklahoma. I am now subject to the state nonprofit statute in Oklahoma, even if my organization is located in Virginia or anywhere else. It's going to be Oklahoma law that applies with respect to decision-making within the organization. Almost every statute, there's some permutations on that, but I think it's fair to say with regard to your organizations, the board is the ultimate decision-making body. And that's really critical because one of the things that occurs when you incorporate in a particular state is this. The state says, okay, we'll give you this corporate shield, right? And again, the corporate shield is what separates the liabilities of the organization, the state councils, from the individuals associated with the organization. But they say, we'll give you that shield only so long as we know that you're going to be operating in a manner that complies with our corporation requirements. At a base level, what those say is, and are there to promote, is decision-making by the board, and I think really the concept that quality decision-making is made by boards after thorough discussion. And so if you are able to say, yes, we are incorporated, yes, we have a board that complies with corporate requirements, and it makes the decisions, then you're able to invoke what's called the business judgment rule. I have it described here as bad decisions are more easily defended than ignorance. This really is true. What the business judgment rule says is that let's say there is a lawsuit, heaven forbid, against your organization, somebody trips and falls at an event, something else occurs. If there's a lawsuit and there's a threshold question of will the organization be responsible for it or will the individuals associated with it be responsible for it, one of the things that they look to is, has this organization, does it have an active board? Are they complying with state corporate requirements? And at a really basic level, those state corporate requirements are these. Actions must be made by the board of directors. Often you will have delegated authority to, say, your chair or to a treasurer or to some other individual. They are allowed to act within that delegated authority. But it's really critical to remember that decisions made on budgets, on more significant items, certainly on commitments of the organization, really need to be made by the board of directors and reflected in the minutes. So again, the requirements are that they must meet and deliberate. I'll talk more about this, but really the requirement is all of these directors must act in the best interests of your organizations. And so if there is ever a conflict between what is in an individual's personal best interest or perhaps align with their own ideological or other stances which are not necessarily aligned with the organization, their obligation is to act in the best interest of the organization. And that's what allows the business judgment rule, the corporate shield, et cetera, to be in place. Another really, really critical thing, make sure that your board decisions are documented through minutes. I'm going to talk in a little bit about what that means, what I like minutes to look like. But I'll say this. I've been through, I've been representing associated with tax-exempt organizations for 25 years now. Every time, unfortunately, that I've seen a lawsuit or an IRS audit come up, the first thing that is asked is the minutes of the organization. And so you want to make sure that you have them, that they're accurate, et cetera. And I'll talk more about what are good minutes, what's good documentation within the organization in a second. But bottom line here is that because there's a benefit from the corporate shield and from being covered by the business judgment rule, you want to make sure that you're complying with corporate requirements. All right, so let's talk more about what those corporate requirements mean. Documentation of corporate requirements in minutes. This is a brief slide, and my guess is I'll probably get some questions about this. I have clients who are all over the board. I met with a client this morning who has not kept minutes in several years. We're sure to address that with them. I met with a client 2 weeks ago who literally had a recorder on and a stenographer and was recording everything that happens in the meeting. This is my recommendation. Minutes should reflect a few things. They should not be verbatim. What I like to do is limit them to the resolution. So anytime that you have the board, this would also, I think, apply to substantial committees, say, okay, we've approved this budget, or we've elected this director, or yes, we're going to take on this program initiative. Make sure that you're asking for a resolution of the board approving that. Of course, you're going to want to make sure, looking at your bylaws, looking at your corporate requirements, that you know that there's a quorum of the board there. A quorum is the number of people who must be there in order for there to be a valid vote. So once you've established in the minute there was a quorum present, ask for resolutions. Also include the material discussion. But my general rule is that brief is better. You don't want it to be so lengthy, the document, that you really have a hard time understanding what was decided, although you do want to have enough detail so that it refreshes individuals' minds and recollections on what needs to be discussed and where we were at the last meeting. Really critical, be sure to reflect in the minutes who was there. Again, this is necessary for establishing that you had a quorum present, that it was a valid vote. Also really critical, if you have individuals who have expressed that they may have a conflict of interest. Let's say, for example, that you have an individual, and this is not uncommon or even on its face illegal. Let's say you have an individual who's sitting on the board of directors. They have a great amount of expertise in a particular educational area that you're wanting to pursue. You were thinking of hiring this individual to do this work. Well, that individual would clearly recuse themselves from any vote approving their contract to work with the organization. And make sure that that recusal is reflected in the minutes. Have one set of minutes. There should not be, it is very common to create drafts. Once you get to a final document, make sure that that is the only document. I've had organizations get audited, which we ask for the minutes, and they have like 5 versions of each set of minutes. You really want to have only the final version that is approved by the board. And this is critical too. Make sure that your board is reviewing the minutes and has an opportunity to give input into the minutes. It's the first thing that I always do in a board meeting, is to ask whether people reviewed and approved the minutes, and remind them, because I've been on boards and I know that it's very difficult to do this, remind them that this is the official documentation of their decisions and how important it is in the corporate shield, as a motivation to get them to review and opine and correct the minutes if necessary, because the board really does need to be in touch with what that document says. Another area, issue number 4, corporate identity. Another area that is really critical is whenever you have an organization with a large number of volunteers, many of your organizations, my guess is, operate entirely on volunteers. There's a question of who has the authority to bind the organization. There's this concept of apparent authority, ulterior actions, that makes many volunteers quite nervous. And it is this in essence. The concept of apparent authority is that if a third party, let's say a vendor, reasonably believes that an individual has the authority to bind an organization, they don't need to do checks to make sure that is the case. They can rely on that perception of authority to bind the organization, and that binding will be backed up by a court, by the law. So let me give you a couple of examples. This almost always comes up in the context of that I've seen, either directors or committee members, other volunteers, and they really, I've never seen a case in which they didn't really mean well. The example I give is several years ago, maybe 10 years ago, I was contacted by a client who, one of their committee members it was an educational committee. They were setting up a big conference. They wanted to have somebody speak at the luncheon who would be sort of an interesting celebrity to drive attendance at the conference. This individual, the person that they contacted, was Bobby Flay. It was actually Bobby Flay's speaking company. Bobby Flay did nothing wrong here, nor did the speaking company, but this is what happened. The individual who was on the committee reached out and said, on behalf of XYZ Tax Exempt, I am the chair of this committee, and we are interested in knowing what it would cost to have Mr. Flay speak at our conference. A quote was given, and the individual responded, "It's a deal." Unfortunately, the individual went back to the committee, found out that Bobby Flay was not quite right for the conference, went back to the speaking bureau and said, you know what, thanks, but no thanks, we're not going to use him. They then got a bill for Bobby Flay on the basis that the individual represented that they were representing the entity, represented that they were the chair of this committee, and said it's a deal. It is that easy for concepts of for an apparent authority obligation to occur. So unfortunately, it's not a defense to say that a board member or an employee was not acting in the scope of his or her actual authority, so long as there's a perception of perceived authority that's reasonable by a third party. So probably all of you are saying, well, great, that's terrifying. What can I do about that? So here are some thoughts that I've accumulated over the years on really how to impact that. A few things. One is to really limit the individuals and make clear to your volunteers who has authority to speak on behalf of the organization, to obtain quotes on behalf of the organization, to sign contracts, to get commitments on behalf of the organization. Often your volunteers are going to be very, very happy to receive this guidance. And to be frank with you, in the cases where I've seen problems with apparent authority come up, like I said before, always well-meaning. And probably, to be frank, the nonprofit let them down by not giving them enough guidance in the beginning on what the scope of their authority is and on this issue of apparent authority. So I like to say, if you're creating a new committee, at the beginning, outline to everybody what their authority is to bind the organization, etc. When you have a new board of directors come on board, be sure to indicate to them what the scope of their authority is. I always like to make really apparent to them, for example, that that board has the ability to only to act as a board through votes, so that you don't have individuals going and making commitments that we don't know whether the full directors would embrace. This next bullet, the second bullet, set parameters around use of association letterhead. As is clear from the word association, this typically is more applicable to C6s and trade associations, C6s which are trade associations and professional societies, because of antitrust concerns. But I think that there's still a lesson here to be learned. The hydro level case, again, I think people learn through examples. You'll remember the examples, not these slides. So quickly, the hydro level case. Committee comes together, decides on certain standards that they're going to promulgate throughout the industry. Chair of the committee sends out a letter on the association's letterhead saying, these are the standards that we're going to follow, knowing full well that that is cutting out one of his competitors and that it's being done for anti-competitive reasons. Now, you don't need to worry about the antitrust elements there. What's important is that the organization was on the hook for it, even though it wasn't authorized. And the reason they were on the hook for it was because that individual had the authority to use the association's letterhead. Very expensive mistake. So I always tell organizations, be careful with your letterhead, have restrictions around and requirements around and approvals when it can be used. And again, educate individuals. Most of these accidents, hydro level notwithstanding, really are accidents. And it's done by well-meaning people. Again, strict parameters around contracting authority and using the organization's name. I can see this becoming maybe a more kind of applicable example for your organizations is, I have a lot of organizations in the C3 space with organizations like yours that have a public mission but also have a very specific policy that they are promoting. Here it would be support and proliferation of laws and circumstances which promote breastfeeding. What I've seen organizations do is not get ahead of the ability to use the organization's name, for example, in Twitter handles, social media, blogs, public statements, etc. And sometimes individual members, while representing themselves truthfully as associated with the organization, will go into the area of making statements which appear to be the position of your organization. And that can become very difficult for the organization if this individual is saying things that you don't want attributed to you or don't align with your particular mission or policy philosophy, or just aren't said the way that you would say them. So again, I think one of the most applicable things for your organizations is to give guidance around social media, blog, other use of your organization's name, and making clear when an individual is speaking on their own behalf versus on behalf of the council. Always fine to have chair of the board. I probably should have put chairwoman of the board for all of you on the phone. But again, be clear with people about the circumstances in which they can use that title, because it does mean that some of their actions will be attributed to you. limit logos and trademarks. It is really important to be clear to your volunteers, to your members, etc., when they can use your logo, when they can use your trademark, because ultimately the way in which they use it ends up impacting your brand, your mission brand, as I like to call it. And so that may not be a legal problem in the end, but it may be a mission identity problem. How does the public view us if there's some dilution because there hasn't been enough clarity around when volunteers can use your logos and trademarks? I already talked about this, prohibiting employees and members from using the organization's name and online identity unless you want it. But one thing that I've seen a lot with organizations, let's say in the example of member organizations, they will create, Facebook pages on, a specialty sub-member segment interested in this issue, but it was never authorized by the main organization. The problem is, if that is created, it is very difficult to say, get Facebook to take it down. The better way is for individuals to know from the very beginning that sub-pages, affiliated pages, etc., really need to be approved by the main organization, and to give them a sense of how that is done. Let me pause there because I'm now going to go to transition into some tax exemption basics, some corporate matters, and IP. That is as far as I'm covering in corporate matters, board of directors, etc. And so if there's any questions that we've received, feel free to raise them now.
Thanks, Lisa. There are actually. And what was the website? Tina has a question which says, what was the website to check your state nonprofit status compliance you mentioned?
So it will be your state corporation commission. So in the example of, let's say again, Oklahoma, what I would do is literally Google Oklahoma State Corporation Commission corporation search.
Perfect.
That should take you to the portion of the website that allows you to input your corporate name to see if you're in good standing.
Perfect. Thank you. So your state corporation commission. Okay. And then again, you did say that, what you need for the minutes to be not the long narrative forms, but just brief and things. And one question is, does the board accept the minutes? So if you have a general membership meeting, does it have to be the full membership that has to accept the minutes of the meeting?
Oh, that's a really good question. So with respect to the board minutes are approved by the board. If you had member minutes, those would be approved by the by the members. But it is the body that took action which approves the minutes reflecting that action.
Great, thank you. And a rule of thumb, what % constitutes a quorum?
Almost always, with respect to the board of directors, except for in Ohio and a couple of other states where I've seen it be lower, almost always it is a majority of the board.
Got it. All right, great. I think those are the questions for now. Thank you, Lisa.
No problem. Okay, tax exemption basics. This is a slide where this is far too simple given the depth of this topic, but I like to cover it at a really high level, but literally I could give an all-day presentation on this. Your organizations which have C3 status have it in a category of tax-exempt status, which is religious, charitable, scientific, testing for public safety, literary or educational purposes. In your particular domain, it would be public education and advocacy related to breastfeeding and related to the public health benefits of breastfeeding. And so it is a very natural fit for C3 status. The benefit of C3 status is that individuals who give donations to the organization are able to take a charitable tax deduction. Now, one of the things I'll note at a really high level is, and I'm sure most of you are aware of this, is that just because you make a payment to a C3 does not mean that the entire payment is eligible for a tax deduction. One of the areas that I see organizations trip up on the most is, for example, let's say that somebody writes a check for attendance at a conference that you're holding on these issues. They have received something back for that, namely the education. And so they could not take a charitable tax deduction on the value of what they have received back. So it is not the case always that you can take a charitable tax deduction. Another example that comes up quite a bit is, let's say that you have a benefit dinner and somebody pays, let's say, $250 to attend that benefit dinner. The IRS requirements are that you back out the value of what they received prior to giving them a donation receipt. So let's say the value of the dinner is $100, the value of the charitable tax donation, tax deduction, sorry, would be the $150 that remains. Some other items. No private inurement. These are kind of very basic requirements for C3 organizations, but where private inurement comes up, inurement is what occurs when an individual who is an insider, that's the legal term, quote, insider, meaning that you sit on the board, or that you are an employee, is also receiving benefits from the organization. Let's say, there's an under-the-table deal that you will receive, 10% of all income which comes into the organization. That's what private inurement is. It's unusual to see it, and usually it happens when, for example, a CEO is being overpaid. I know that is not the case in any of your organizations. Then the IRS will come in and say the value of what they provided in terms of CEO services was this. Let's say it was $100 a year. They received $200 a year. We're going to say that that extra $100 was private inurement because they were an insider and because they weren't, they received payments for which they were not due. Again, it's not an area that typically comes up with organizations such as yours. Private benefit is, again, another nuanced tax concept. Again, I could talk about it for a day. The basic is that inurement applies to individuals who are insiders within the organization. Benefit applies to individuals or organizations which are not insiders, but which disproportionately and illegally benefit from the organization. So an example would be, we had a client years ago which did broad education in methods. This particular organization was a bridge safety organization. It was on methods to apply paint to rusting surfaces. Very exciting. They came to us and said, there is a new technology for applying paint, and it is only patented by one organization, by one for-profit entity, and they've come to us and asked if we'll do the training for them. They didn't end up doing the training, and the reason was private benefit. We were very concerned that because there was only one entity in this field, that it could look like they were subsidizing what should otherwise be a for-profit entity's cost. Again, I raise this so that people can walk away from this and say, yes, I'm familiar with the basic requirements for C3 entities, but I would be surprised if any of these issues have come up with your organizations. There is also the issue, and this is not the crux of this presentation today, nor frankly is it my strongest area of expertise, but related to lobbying and to PACs. To be clear, 501c3 organizations are allowed to engage in lobbying, and I would recommend, if any of you are wanting to have more information on that, I would Google Venable nonprofits and lobbying. We have great educational materials on what C3 organizations can do in terms of lobbying, both grassroots and otherwise. But just to be aware that lobbying it has a particular definition, which is to influence a particular statute or legislation. Broader education on the impact of legislation typically will not be lobbying, but you should be aware of those if your organization is engaged in anything that kind of abuts on lobbying. The other is political activities, campaign activities, donations to PACs, just almost always completely, well actually always, completely prohibited and can result in loss of tax-exempt status. That said, there are nuances around when organizations can do education, bipartisan education, on where candidates stand. Again, Venable has some good materials about this. But one example is, for example, if you were to send out, your counsel, a pamphlet which says, our counsel does not support, I'm just going to pick a candidate, Donald Trump, because of X, Y, Z. That would most likely be seen as electioneering, as promoting Hillary Clinton for president. But if you instead sent out a pamphlet which said, know where the candidates stand on support for X, Y, Z, and had a presentation of the information on a bipartisan basis, then the IRS has said that really falls into the category of public education. Again, there's some good nuanced materials. A colleague of mine just wrote a nice client alert on this issue, but it's a nuanced one, and if you're involved in this, I really recommend that you understand the requirements, because again, if you run afoul of the political activities as a C3, the only remedy is loss of tax-exempt status. Okay, I know that went by in a blitz, but we have, I'm going to move on now to contract management. And again, feel free to present any or to bring up any questions you have on that. Sorry. The first thing I have on contract management, which again is, my next issue, is to really understand, and this is not a legal point, sorry I keep on switching around here, to really understand that you maximize what you get out of any contract negotiation by understanding the position of your posture. Now, I understand that most of your organizations probably are doing very little contracting, and you probably don't have a ton of leverage. But I will talk in the next few slides about how to understand contracts as a non-lawyer, and to understanding some of the points that can become more contentious and that you should focus more of your resources on. But, as a general matter, if you have the ability, if you have outside counsel and you have the ability to do some of these things, these are my recommendation. Always start off when you see a contract, when you're discussing a new potential arrangement, understanding what's most important to your organization. If it's possible, for example, to tell a vendor, we only agree to an indemnity agreement, and I'll talk about what that is in a little bit, which contains these provisions, you are much more likely to get it than if you only think about this after you've gone very far down the road and they basically know they have you. Kind of the basic rule I have here is that before the other party knows that you're interested, that you're going to sign, and that you need them, make sure that you've thought about what you need the contract to look like. Because if you're already kind of going down the road of performing what they were going to do for you, or they know that you have settled on them, it is much more difficult to get things in the contract. If you can, of course, lead with your own contract drafts, but again, that may not be possible. At least know what contract points are central and important for your organization. Again, this may not be a point that you can follow for some small organizations, but I always say competition reaps savings. Request for proposals is one way to do that, but there's a number of ways to do that. To this day, even if I am going out personally to get, say, a handyman, I tell everybody, I'm speaking to 3 people, what is your best offer, and tell me what the elements of this are. I would recommend the same within your organizations. Even if it may not necessarily be the case that you're going to get multiple bids or multiple, always sort of indicate that you're looking at multiple parties. I think that it helps quite a bit in them trying to woo you, if you will. The other thing is you can get greater benefit out of an arrangement if you are willing to have a multi-year deal or, say, use a one facility multiple times. Let's say, for example, that you have every year or twice a year educational sessions and you need to book a meeting space for it. my experience is that you are going to get more out of the relationship, both in terms of the quality of service and in terms of what they're willing to negotiate with you, if you tell them, we want to use you twice a year for the next 3 years. My board's going to have to approve this annually, but to the extent that things are going well and they feel like you're working with us, I'm going to have a much easier time in getting that done. So again, motivate individuals to think of you as a long-term partner to the extent that you can, to try to get as much negotiation posture as you can, as early as you can. Which leads us to, okay, so I'm sitting within an organization, I receive a contract, I do not know what to do with it, I'm not a lawyer, what are some contract basics? And this is issues both 7 and 8, because we're going to go into this with a little bit of depth. So this is my hokey sport way for you to understand, to remember this: scope, payment, ownership, responsibility, and term and termination. Sport. These are the elements, although contracts vary widely and there are many things to understand about them. I think that if you're a non-lawyer and you can look at a contract and be able to identify some of these elements, you're going to be in a much better position. So what do they mean? All right, scope. Scope, and this is incredible to say, but the vast majority of the time that I receive a contract from a client, the problem is in scope. And scope is, what are you getting? Scope is the scope of services. It's usually, it will be an addendum or it will be right at the beginning. But you know, the key thing is that you want to be able to understand what is being done by the other party, or what are you doing for the other party. And I'm surprised by how often my clients, organizations, will go through a very long process, send me what they think is a final negotiated contract. You open the contract and you cannot tell literally what anybody is doing. Although you can tell when it's going to be terminated and how much you have to pay for it, you don't know what you're contracting for. So always make sure that you can answer some of these questions. What is being done? Who is doing it? When will it be done? When will it be delivered? I added more there, but who is doing it is something that should be there too. Bottom line, and I've been through this a lot, litigation, disputes, etc., almost always come because of a lack of specificity regarding scope. What did you say that you're going to do in the contract? Really, really key. Any elements related to scope or anything else, they need to be in the contract. There's what's called, what I call, at least, I don't know if people call it, I call it a four corners rule, which is that anything that is an understanding of the parties needs to be within the contract. And generally the rule is that it has to be able to be understood by a third party who has no inside knowledge. So, as an example, if you have entered into a contract to receive services, and there are really material elements of this for you, but those are embedded in emails or phone discussions, etc., stop. Make sure that it's embedded within the main body of the agreement, because that is the only thing that you can use to say that the other party is in breach. Also really critical, the only way to get out of the contract because you haven't gotten what you thought you were going to receive is by saying that the other party has failed to perform. And so this issue of scope goes to that as well. If it's not clear what the other party or you are supposed to perform, it is very difficult to get out of the contract, even if you feel that there's been non-performance. Payment. Of course, really, really critical. What I like to do as much as possible is to tie payment to the satisfactory delivery of whatever the other party said they were going to do. So, example, last night I was reviewing a contract that provided for a vendor, an educational consultant, to deliver a report on areas that are important to my client. The payment, however, was entirely due at the beginning of the contract. And so what we did was gave some of the payment in the beginning of the contract because understandably the other party needs to make payroll, has its own obligations, gave another chunk halfway through when it was clear whether or not the party was making progress against deliverables, was on time, and then the last chunk at the very end once we approved the report. Can't say it strongly enough, your ability to go back and tell somebody, and I don't like this, is greatly diminished if you've already paid for it. Again, something I learned mostly just from house improvement is that you don't want to pay your handyman before he's done the work, he or she's done the work. Same concept here. People are motivated to perform well when you still owe them money. So payment. Make sure that it's clear what you pay. Make sure that it's tied, if you can, to when you're going to receive. Ownership. I'll talk about this more later, but for organizations such as yours, your intellectual capital, your educational materials, your policy materials, etc., are a huge part of the value proposition and the mission, your ability to deliver on that value proposition within your communities. I'll again talk more about it, but the basic concept here is that whoever creates a work can be a photograph, it's anything in a tangible medium, but that can be a photograph, it can be your website, it can be an educational material. Unless the contract clearly provides that your vendor is assigning or licensing or giving you the copyright to those materials, your vendor still owns them, even if you paid them. So I'll give you an example. A couple of years ago, had a client come to us and say, we hired a photographer. Photographer took photos at our event. We paid this individual, I don't know, $500. Now the photographer is saying he needs additional income to give us the photos. And their complaint was, well, but we paid him. You did, but you never got an assignment of the IP in those photos as part of the contract. So ownership, make clear who owns, and make clear that if you have an interest in owning the materials that are created under that contract, that it's clear that you are going to own those materials. That is was going to be more of that on topics 9 and 10, so I'll leave that for there. But again, ownership is really critical. Responsibility. This is, for lack of a better term, when things go wrong. Responsibility primarily relates to the indemnity clause. When you see a clause in your contract that says, or a contract that you're reviewing that says, XYZ hereby indemnifies vendor for, that is what this provision is. And what it really relates to is if something goes wrong, if there's harm resulting from the contract, who's responsible for it? Now, your organizations are somewhat smaller, and so I think that you're in particularly a good position to say we have, certain indemnities that we will agree to kind of across the board, and this is what I recommend. In general, I recommend a reciprocal clause. What that means is that if your vendor is asking your local counsel to indemnify them, they should certainly be indemnifying you. And most likely, it should have very similar language, i.e. you indemnify them for your negligence. They should similarly indemnify you for their negligence. I have this note here, which is the fourth one underneath responsibility, no sole, gross, or as determined by a court. If you see something in the contract which says vendor will indemnify counsel for its sole negligence or gross negligence or its negligence as determined by a court, strike it. I like to have it just be simple negligence. Vendor will indemnify for its negligence and that of its employees, etc. Sole and gross are very high thresholds for negligence. Even if it's reciprocal, if the other party is doing most of the services, I don't think you get much of a benefit out of you're only responsible for your gross negligence, but oh, by the way, you're not doing anything, and you've just agreed to a limitation on the other side of gross negligence. As determined by a court requires you literally to go through litigation and have a court define that one party or the other is liable, it is still the case that less than 5% of all claims in the United States are adjudicated. I have, in the time that I've been practicing, only seen 2 clients go all the way through a court case. So it is most likely never going to be determined by a court, instead settled out of court. Strike as determined by a court. Really critical, I like to, as much as possible, have my indemnity limited to things that I can control. So let's say that I'm one of the counsels now. What I will say is counsel agrees to indemnify for its negligence and the negligence of its agents and employees. What you don't want, for example, is to be covering any potential liability that might arise from anybody who's your volunteer or your member. Let's say that you're having, for example, a fun run. You don't want to be responsible for everybody who's in the fun run. You can't control all of their acts. I understand, again, that there are times when you can't get out of that, but to kind of give to give full or flavor to what an indemnity is and what it means, just look out for whether or not the organization is required to cover the liabilities which arise from people they cannot control. Term and termination. A couple of things on this. Number one, beware of what a client once called evergreen provisions, which is the provision which says this contract shall automatically renew unless either party gives notice of an intent not to renew 30 days in advance, something like that. Again, if you're comfortable with that renewing, if, say, it's an agreement, in a grant agreement, and the donor is agreeing to give you a new donation, it works in your favor. Let's say it's a sponsorship agreement, and the sponsor agrees to sponsor multiple meetings. It works in your favor. But be aware of it, and beware when it really works against you, that you don't want to have to keep track of all of these deadlines and then be stuck in another contract that's renewed. If you do have an evergreen provision, just be aware of, make a note at the top of the contract, we have to give notice by XYZ date that we're not renewing, so that you're aware of that. What I always tell people is contracts are living documents. Don't sign it and put it in a drawer. Remember that the obligations are living, and again, this concept of the 4 corners rule, in the event of any kind of disagreement about what applies, it's that contract. So know what deadlines there are, and particularly as they relate to termination. Note the notice period and the grounds for termination. This is really critical. If there is something that would happen which would make you not want to use a particular vendor, let me give you an example. I have a client which very frequently does research contracts with universities on particular topics. What we have done is that, because usually what you're really wanting is you want the university, but you really want a particular researcher, a particular PI, right? And so we have learned to say our organization can terminate this contract in the event that this particular individual is no longer available to work on this research project. That is the kind of thing that you want to identify at the outset, that if this happened, you want to be able to get out of the contract because it really undermines the reason that you entered into it. So always be aware of that as well, fully defining what grounds for termination are. I'm now going to segue and talk for, I don't know, 10 or 15 minutes about infringement, about intellectual property. Can I ask, have any questions come up on these slides? Because before I kind of switch gears, I want to make sure that I address them.
Sure, Lisa, and gosh, what a wealth of information, whether you're a veteran nonprofit or just starting to begin the process. We had a question about the meeting, again, the documentation record keeping, and it is if there are actions noted in the meeting minutes, such as, action taken on the budget or action taken on a certain policy, would the minutes also encompass all the attachments and the other ancillary related documents?
Really good point. Yes. really good point, and I should have covered that. What I like to do is any materials that were reviewed by the board in coming to its decision, attach them. The reason it's important is that, for example, let's say that you decided to take a particular investment course based on analytics of how that investment fund has done over the previous 5 years. You would want the analytics attached to the minutes. Again, boards of directors don't have to make perfect decisions, but those minutes document what decisions they made and what they reviewed in making those decisions, so that you can, a court or later can determine were those decisions reasonable at the time. So yes, good idea to also attach the affiliated documents.
Great, thank you. And your examples are so spot on. Our coalitions are largely volunteer-based, and a big chunk of many of their revenues come from educational events like conferences and things. And the apparent perception of apparent authority, who's using the letterhead, inviting speakers, promising them things, and doing that. So very, very relevant to all of us. So thank you for that, Lisa. And I think those are the questions for now.
Okay, excellent. Okay, so I'm going to go on and talk for, again, 10 or so minutes on my last two topics, which are intellectual property, documenting what you own, and protecting against infringement. And then we can open it up at the end for just, general questions, which I'm happy to answer or to say I don't know the answer to that. So, all right, at a really high level. My background, as Kenny brought up earlier, is that I was, previous to becoming a lawyer, an executive director of a think tank, and we did counterterrorism research. And so the vast majority of kind of the value of our organization was in that research and within our related, kind of policy papers. I'm embarrassed to say that at the time that I was an executive director, I knew nothing about IP, and so I literally broke all of these rules, but you can learn from my mistakes. These are the things I did not know at the time, and that would have made me take a different path if I had known them. Number one, employees who create things for the organization, so long as what they create is within the scope of their employment, those works are automatically owned by the organization. So going back to my example of when I worked in the counterterrorism field, anything I would have created related to counterterrorism, related to the Institute, would have been owned by the Institute because it was within the scope of my employment. And employee works are owned immediately or automatically owned by the employer. But nuance on that, if they had asked me to come and take photos at one of their meetings, I think there would be a very good argument that that was outside of the scope of my employment. I was a researcher and an executive director, not a photographer. So not everything that is included in an employee's scope of work will be owned. I'm sorry, not everything that an employee does will be owned by the organization. But so long as it's within the scope of their work, it will be. Contrast that to the rest of the universe, which is vendors, authors and speakers, individuals who are volunteers. Anything that they create is not owned by your organization, even if you pay for it, unless there is an assignment or a license for ownership. Now, again, don't be, afraid, very afraid. There is a concept of an implicit license. It's called an implied license. And, frankly, the fact that you don't have explicit rights to use some of these things does not mean that you automatically have a problem. What you do have a problem is if an author, a speaker, a vendor comes back to you later and says, I did not authorize your use of those materials. Then you have a problem because you don't have an assignment or license. So, you sort of don't lose it about what you've done in the past. I have some ideas on the ways that you can do this in the future, but just for clarity, people who are, for example, your website designers, your photographers who write articles for you, who do speeches, who do PowerPoint presentations at your meetings, people who sit on committees to help on position papers, to assist in articles. They, as a technical matter, continue to own the intellectual property in those items, and your organization does not have the right to use it without an explicit assignment or license. So how do you do this? It's really kind of startlingly easy in a lot of ways. Licenses and assignments are very, very simple to draft. An assignment means that all ownership in the copyright, which again, copyright is anything fixed in a tangible medium, can be a website, can be a photograph, can be anything fixed, can be a paper. An assignment means that the person who created that no longer has any rights to it, and that your organization has all the rights to it. It is as simple as saying, ABC organization or ABC individual hereby assigns all right, title, and interest, and then you would say what they created to the council. Very simple. It can be a sentence. The kind of key thing here is that assignments are most often appropriate for, say, if volunteers are sitting on a committee to come up with a policy position, there clearly you don't want them to use the same materials in the future. It would be appropriate for them to assign it. Certainly anybody that you're paying for the creation of intellectual property should assign it. Where it becomes more nuanced, frankly, is in the researcher university context and in speaker context. Often universities will have rules around their faculty having to publish. And so what often will happen is that a faculty member will come back to you and say, yes, I'm comfortable with the council using it, but I'm not comfortable with them having the sole right to use it. Same thing with speakers. For example, this presentation. Perfectly happy to have the council use it in the future, but I would still like to be able to use these slides in the future for other purposes. So that would be an example of shared ownership. Shared ownership means I hereby give you a license to use the materials in pursuit of your educational purposes and retain a license to use it in pursuit of my professional purposes, for example. Licenses, again, it is not a highly nuanced area unless it's a very complex issue. You can probably find examples of simple licensing language that you can use in a pinch, but the really critical thing is a few. Yeah, I'm going to define it on the next slide. That you want to define your how it's going to be used, where it's going to be used. I'll talk about that on the next slide. Implied licenses. Again, if you don't have a license with an individual or a contributor, it doesn't mean that you can't use it. If, for example, somebody gave you materials in the course of sitting on a committee and now comes back and says, I didn't want you to use them, there is the ability to say, we thought by sitting on this committee that you clearly were giving us a license and we're going to continue using them. Most likely a court's going to back you up on that. But what's really critical is that the only thing that you can obtain by course of conduct, by it being implied, is a license. It's not ownership. Ownership of material can only be done in writing via contract, via an assignment. So if you're trying to exclude anybody from using something that they gave to you that you thought you were going to be able to use exclusively, you're not going to be able to get there unless you have a written document. But if you're simply wanting to say, we thought that we had the ability to use this in implied license, you probably could. But again, it's narrowly construed and really subject to interpretation. The license, which I'll talk about, means that each party retains rights to use it, but the license talks about how and why and when they can use it. Okay, so let's talk about that. Some of the things you want to think about in a license, and when will this come up? For your organizations, I think this is going to come up a lot around educational sessions. Again, somebody presents a paper or a PowerPoint. You really want to get a license from them, which would say, let's just give the example of me. I, Lisa Hicks, hereby license to XYZ Council the right to use my PowerPoint as presented on 9/21. including the ability, and this is where we get to future uses, including the ability to put it on your website and use it in for future purposes consistent with your tax-exempt mission. There's this concept of derivative works, which is that if you want the ability to, say, take my presentation, slice it and dice it, create another presentation from it, that's a work that's derived from my original work, right? You need the ability, you need to have the ability to create derivative works stated in the license. So, for example, if you commission somebody to, or you ask somebody to write a booklet on compliance with family medical leave, and then there is an update in the family medical leave law. If they gave you a license to use it, if you don't have the right to create derivative works, you don't have the ability to edit, update, et cetera, that pamphlet. So think through, will we ever want to modify this in the future? And if so, do we want the ability to create derivative works in the future? So for example, if you want to be able to publish it in your magazine, publish it online, update it, et cetera, you want all of that to be contemplated within the document. Define the geographic area. Here again, I think it's easiest to say you have the license to use my PowerPoint for purposes consistent with your tax-exempt status, to create derivative works, and to use such works internationally. That's the kind of default, but know that if the license says something like in Oklahoma, which again is where I'm from, you only have the ability to use it in Oklahoma. So you want to have a broad geographic scope. You also want it to be clear whether the license is exclusive or non-exclusive. So for example, if one of your authors gives you, let's say the National Council, gives the National Council the right to use these materials, that right only goes to your main corporate entity. The council couldn't, for example, share the ability to use those materials with local state entities unless there is a provision which says, and the right to a sub-license. If it says, gives you the exclusive right, that means that you can't share it. So you need to think through that as well and make sure that you have adequate coverage. I always like to put in a perpetual license. We have the right to use it at any time, and make sure that it's clear whether or not you're paying for it. So for example, if you are not going to pay a speaker, but you want to be able to use their PowerPoint, you would say, we are obtaining a license to use this in the future without future consideration or payment. Because otherwise you're opening yourself up to the possibility that somebody will come back and use it in the future. Now, one of the questions I get a lot is fair use. Again, fair use is something I could talk about for a day. It's a nuanced area. What I want to say is that fair use is extremely limited. So if somebody is using your materials or you're using somebody else's materials, don't take for granted that you fall under a fair use exception. Most likely you don't, because often it has to be used in academic settings, not commercial. It has to be a very small portion, i.e. not the entire material. So fair use is often not the defense that you want to be falling on. Some practical tips related to this. I like to obtain licenses from all authors, all speakers, anybody who contributes intellectual capital to your organization. I adopt a standard policy and practice for all volunteers and for committee work. For example, what I'll do is if I have a new committee that's going to create a policy document, at the first meeting of that committee, I will ask them to give me either an assignment or a license to use anything that they create in the course of their committee work. So that, a lot of this is in the approach, the communications, the touch. People are much more receptive to signing this if it feels like something they're doing at the beginning of their work and it's just a matter of course, than if they have to do it 3 years after they've heard from you and it's really kind of cleanup. Just do it from the beginning and do it broadly. I think this is a really good idea to kind of adopt a standard agreement within your organizations and just make sure that you have the ability to use these materials broadly. This point about publishing and posting online, Quickly, there was I think it was the Sonsini case. The New York Times, for years and years and years, before we thought about something called the internet, before it existed, had agreements with all of their freelancers which say, you assign the rights to use your materials in our newspaper. They didn't think yet about online use of it. It wasn't contemplated. When the rise of the internet came about, they started archiving old articles on the internet. Goes to the Supreme Court comes back and says, no, sorry, that wasn't contemplated within the scope of your license. It's a bit of an outdated concept now because the internet is so common, but just make sure that if you get, for example, a sample or a template license agreement, that it doesn't say that you only have the ability to use it in written form, that you also have the ability to use it online, and I usually say in any other form of communication now existing or hereinafter developed, so that you can create, that that you can use it in whatever it is we're going to be using in 15 years, virtual reality machines or whatever it is. Paid contractors should always agree to a standard assignment for their IP. Make sure that that's put in all of your contracts. And then when you're allowing other people to use your own intellectual property, and here I'm talking about the counsel's intellectual property, make sure that the ways in which they can use it, the duration for which they can use it is clear. If you want attribution to your organization, make sure that that is clear as well. But also really critically, if you're giving a license to use something that your organization has, make sure you own it. An example, and make sure that the people who are giving it to you own it. This issue comes up all of the time. Somebody has embedded either within a PowerPoint or with an article a photo or a graphic that they found online. Again, they had the concept that things you find online are sort of up for grabs and that it's fair use. It's not. I see often organizations, they've got a PowerPoint from a speaker on their website. Somebody will contact them and say, you owe me because that's my photo and you're using it. So always make sure that you own what you're giving away, and make sure that you get a representation from people who are giving you things, or organizations who are giving you things, that they own what they are giving to you or what they're licensing for you to use. So that concludes, and we're doing pretty well on time. We wanted to save 10 to 15 minutes at the end for general questions and follow-up. This is my how you can reach me. I'm happy to answer any follow-up questions, but Kenny, this would be the time if there's more questions that would come up and any kind of follow-up items. I'm happy to address those now.
Thanks, Lisa. And we do have a question. You answered most elements of this already, talking about paid contractors agreeing to standard assignment, but this is a specific question. It says, if a member creates a training tool and is paid as an independent contractor, but the coalition's website, the nonprofit's website, hosts the end product, does the individual author own the product still? Does there need to be a written agreement? Over time, can the nonprofit own this? And I guess the devil is in the details of the contract, if you can.
Right. Yeah, so at a high level, let's say that you have found something on your website that's incredibly valuable, but you're very concerned that you didn't get an assignment originally. If you don't have an assignment, again, even if it was paid for as a technical matter, you do not have the right to use it. A couple ways to approach this. One is simply to go back to the vendor and to obtain an assignment. The second is to, kind of, frankly, fly under the radar and see if they raise a concern. That is what the vast majority of tax-exempt organizations in this country are doing right now, because I know that it's very difficult to always make sure that you have these assignments. Can you own it over time if you simply continue to use it? For copyrighted items, the answer is no. The only way that you can come to own copyright is through an explicit assignment. That is more nuanced in the area of trademark, but we didn't go into that, and I think that's probably more than you want to hear about. But no, even if you exclusively used it and you had it prominently on your website for, say, 10 years, if you never got an assignment from the individual, technically you don't own it. again, what do you do to remedy that depends on whether they've raised it or not.
Thank you. This is a really broad question, but when you spoke about controlling liabilities and kind of shifting the risk or sharing the risk, as one question is, as you're thinking of safeguards, as you're building into our processes to mitigate harm, is there anything you can speak about crisis management? We think about crisis management when it happens, and so that's the question. How might we plan a little better for the crisis?
Yeah, so there are crisis management, enterprise management. These are big, enterprise risk management, big code words right now. How to plan for this. What I'll say is, this is maybe a little bit against interest, but you don't have to have an attorney for a lot of these things. There are organizations that are rich in resources. For example, the Foundation Center has terrific free or low-cost materials in a lot of these areas. I recommend that you become, familiar with that. With them, they're terrific. In terms, kind of generally, what do you think about? There's a lot of elements to this. On financial risk management, it's, do you have only one individual who can make withdrawals, or is that multiple individuals? Do you have checks and balances on that? So there, there's that. Most likely your financial provider and your auditor will have guidelines for you if you have an auditor. Not everybody's required to have one. Have guidelines for you on how to do that. In terms of other areas of risk management and prioritizing your efforts, again, I think making sure that you're a properly constituted tax-exempt organization, making sure that you have a central set of files, and hopefully that you have copies of all of your contracts will get you a lot of the way, so that it's hard to forecast into the future what these risks or crises might be. But if you have a central location with all of your central commitments and corporate documents, it's a lot easier to answer what is our obligation here or there. Beyond that, it really depends on the specific nature of the crisis, but those are my broad thoughts. Any other questions?
I can't hear anything.
All right. Oh, I'm asking if there's any other questions.
Mm-hmm.
Sorry, everybody on the line.
We can hear you, Kinkini. I think Kinkini's chatting me. This is Megan Renner from USBC. She's chatting me that she may have lost audio. Apologies about that, Lisa.
I'm back.
No problem.
I'm back.
Oh, there
I'm
you
so
are. Okay.
so sorry. For some reason, the audio just went. So thank you, Lisa. And I wanted to invite Megan if you wanted to, add anything. I know our members have membership to the Foundation Center through our organizational membership. Anything else you wanted to add, Megan?
Yeah, I think that's a great thing to plug. That we do have board source membership for the coalitions, and it's not actually a membership to the Foundation Center, but we do have access to the Foundation Center directory that we have available to folks. So just a reminder about those resources. We also have a membership to the Nonprofit Risk Management Institute.
And they are excellent. Excellent.
Yeah. They're really have some fabulous resources. So if you're listening to this webinar and getting on the radar screen with some of these questions, please do look for those bits of information and resources. They are available to you all in the Coalition's Learning Connection. So on that landing page, there is information about these coalition benefits and access. We also have links there to, because Venable does a wealth of regular, is it monthly, Lisa?
Monthly.
Yeah, monthly webinars. There's whole archives with very, more specific detail about lots and lots of issues. So if you haven't checked those out, we have a link to that in the same place, the coalition benefits. And then similarly, we also have a link, USBC's audit firm, a company called Orba, does similar financial seminars that they offer and have as a free resource. So those are there for you as well. So please check all those out, and certainly, if there's anything, you're looking for a minutes template example, or some of these things, please reach out to Kinkini and Danae on the Coalition's @US Breastfeeding email address, and we'd be happy to share with you some of our examples. I know I hear from folks from time to time with questions about insurance or questions about, contract examples. We're always happy to share our resources and experiences on these kinds of issues. So this has been really great. Thanks so much, Lisa.
Of course. Thank you.
And that brings us to the end of today's session. Thank you, Lisa, for this terrific presentation. I know that I will be, and many, many members of our network who've listened live will also be revisiting the recording, because there was just such a wealth of information and just so much that we will be using as we strengthen our organizational capacity. So thank you, Lisa. And to our participants, thank you for all you do to improve the lives of women, children, and families. I want to remind you that next Tuesday, September 27th, we'll be bringing you the next webinar in our racial equity series. It's titled "What's Stress Got to Do with It?" Talks about toxic stress and the effects of racism and its relation to chronic disease. So I hope you'll join us for it. And goodbye for now, and I look forward to having you all for our next Power Tools webinar session. Thanks, everyone.